Life Management Science Labs would like to acknowledge that we live and produce this podcast on the traditional lands of the Wurundjeri people. We'd also like to acknowledge the traditional owners of the lands of our listeners and our international colleagues. We'd like to pay our respects to their elders past, present, and emerging. Hey everyone, and welcome to All Together, the Family Science Insights podcast, produced by LMSL, the Life Management Science Labs. We are champions of life management science, providing structured insights informed by science and inspired by practice on key aspects of conscious living. Each week we bring you scientific and practical insights on each element, with the expert knowledge of professionals in the field. I'm your host, Dina Sargeant. Let's get started. Hey guys, and welcome back to another episode. Now, a prenup can be seen as protecting both sides of the union. I've heard so many conversations of the underlying meaning that can be portrayed, including the thought that a prenup is due to the lack of trust in the marriage's longevity. Or maybe it may make them feel like you are the only one, that you are only there with them for money or for any sort of social circumstance. It is definitely not an easy discussion to bring up with a future spouse, but it is a very important one, which is why our episode today is going to be decoding prenups in today's relationships. Our guest today is from a legal perspective, with an interest in all aspects of family law, both from a historical and a contemporary perspective. He is a senior lecturer in law at Macquarie University in Sydney. Please welcome Dr. Henry Kha to the studio.
Thank you, Dina.
It's so great to have you on because we've never had an actual legal perspective onto an aspect on the show today. So it's so great to have a little bit more of what it is in the meaning of what a prenup is and in terms of how it sort of fits in with the way that marriages work in today's society. So as a professional, what is your role in helping families and couples get a deeper understanding into the legal knowledge of a prenup?
So I'm a university lecturer, and my main role is to research different aspects of family law. And one major aspect is the division of family property after separation or divorce. And prenuptial agreements, as they are colloquially known as, feature as a significant aspect of prenuptial agreements, also of family property law. What my research endeavours to achieve is a better understanding of how the law works, provide more insights into different aspects of the law, particularly how the law is interpreted by the courts and how they're implemented in practice. It's one thing to have the statute books and the laws. It's another thing for the courts to make decisions in cases involving ordinary people and how ordinary people implement decisions based on the law.
Mm-hmm. So there's a huge difference between what's historically known as the law and what people use it for now, I would assume then.
Yeah. I mean, the idea of prenuptial agreements as being legally enforceable is a relatively modern thing. Historically, prenuptial agreements were not legally enforceable as a matter of public policy. The reason being it was because the idea of a prenuptial agreement was seen as conducive to divorce, and it also meant that parties were contracting out of the court's jurisdiction and wanted to ensure that they had the ultimate say and could make decisions if a property dispute arose in the family law context. So in Australia, in particular, prenuptial agreements, or as they are more formally known as binding financial agreements, have only been around since the year 2000. So it's quite, as I said, a relatively modern thing that has existed in family law.
Mm-hmm. And when you hear, when people talk about prenuptial agreement, what's the most common frustration that they sort of get when, I think I mentioned earlier that some people see prenuptial agreement as being a positive and a negative. Is it more common that people see the negative sides to it, or is it also they do see the benefits that sort of come across?
Well, prenuptial agreements have been interpreted both positively and negatively. Obviously, there is some resistance to the whole idea of a prenuptial agreement that couples, before they get married, are contemplating the hypothetical prospect of getting divorced. And obviously, it's not very romantic to discuss about prenuptial agreements just before getting married. So that's the critical angle in regards to prenuptial agreements. But in terms of why it exists and why many couples have opted to enter into prenuptial agreements, it is because of, I think, three main reasons. One is wealth disparity between the couple. Another reason is associated with dynastic wealth. So a person who is born in a wealthy family may feel pressure from their parents to sign a prenuptial agreement before they get married, because that person is expected to inherit a lot of money in the future. So a prenuptial agreement can be used as a form of wealth protection. And it's also commonly used in the context of second or later marriages. So couples who have previously had relationships but have been burnt financially as a result of separation are a bit more wary second time or even third time round and opt to have a prenuptial agreement to protect their wealth and assets, not only for themselves but also for children from previous relationships. That's a reason why couples may elect to have prenuptial agreements to ensure that their wealth is preserved for their own children.
Now, that's such a great introduction to our topic today, and I can't wait to discuss it further. But before we do, I love to start off with a little get to know you, sort of like get some of your recommendations and some of your passions as well. So to start off with, what is the most recent book that you've read?
Well, I'm currently reading a book on the history of Vietnam. So I really like to read books about history. One of my research areas is legal history, but I like to look at history more generally. So it's quite a fascinating read to see how Vietnam has transformed into the modern state. And, in the 20th century, it was embroiled in a lot of conflict. So it is interesting to see how they have managed to deal with so much calamity in their recent history.
So I definitely love learning more about history. So that's a really exciting book, it sounds. Now, what is the movie that you would recommend to our viewers?
Okay, that's an interesting question. I really enjoyed Quentin Tarantino's film Pulp Fiction. It's really exciting. It's the story's told in a non-linear way, which makes it more intriguing to watch. There's a lot of action, and that may not be everyone's cup of tea, but for me, I think it's a fun movie to watch. And if you're out for a good time, Pulp Fiction's a good movie to pick.
I'm so glad someone finally suggested Pulp Fiction. I think we don't get that much that often, and I love that movie so much. During my uni degree, I had to dissect each of the characters and each of the film in so many different ways. So I love that film very intimately now. Now, could you name a podcast that actually really stands out to you?
ABC Revision. For your foreign listeners, the ABC stands for the Australian Broadcasting Corporation. So that's Australia's national radio broadcaster, as well as TV. And Revision is a podcast about various current affairs issues. I've appeared on Revision once to talk about the history of the family court in Australia. And each week they showcase a different issue, and they go through the issue in significant detail. So I'm always exploring new ideas when I listen to that podcast.
That sounds like a really important podcast to really just sit down and listen to and really learn from. Now, who is a person that you find yourself looking up to?
Okay, so in regards to a famous role model, your listeners probably won't know this person, but he was famous during his time. His name is David Shepherd. He was the captain of the English cricket team, and he later became a bishop in the Church of England. What I am impressed about is all the achievements he had accomplished in his life. To be world-class cricketer, to leading a diocese. The reason why I think he's a good role model was because he was actively involved in this community. He was striving to improve relations between different peoples. He fought against racism and tried to help alleviate poverty. And my interest in family law is also concerned with trying to make society a better place. I think that's the reason why I've chosen him as a role model, to try to find ways to strive to be a better person. And I think it is a noble goal to try to make society and the community stronger and more resilient.
That is a big change in profession, going from a cricketer to a bishop. That is that is a huge change. It's amazing to see what he's done with that, and he's done since then. So I can definitely see why. Now, during your academic pursuit, what's been one course that has really stuck to you to this day?
Of course, it's family law. I'm a family law academic. I really enjoyed studying family law when I was a law student. And the reason why was it's about people, and people are very fascinating and interesting. In law, you learn about all sorts of topics, and look, that they're very important too. And I also enjoyed studying different subject matters. But with family law, it's quite an eclectic subject. There are so many topics, you never get bored. So on the one hand, I could be researching parenting matters. Then next moment, I'm looking at doctrinal property matters and international child abduction, adoption law, surrogacy. As you can see, there are quite a lot of ethical issues in family law. So I think that makes it interesting. With family law, the fundamental question that people are asking is what makes for a good life? Because judges have to make decisions about people's futures, whether that be who the children spends time with, or how family property is divided. How should people live their lives after separation? And I think that is really a profound existential question. That's why I got interested in family law.
No, I agree. I think even just the social aspects to it, I think family, just the whole aspect of family is very interesting. That's why I do this show. It's one of the most interesting aspects to really look into. So I can definitely see how law really fits into that. Now, I know that everyone has a very different definition as to what family is. To you, what would your definition of a family be?
That's a very good question. The idea of family has changed, particularly people's imagination of the formation of family. But I don't think in substance it's changed too much. I think the nuclear family is still the standard model that people aspire to. Most people would be in a family that resembles the nuclear family. So just to clarify, the nuclear family is mum, dad, and kids. And that it has been a universal pattern. Now, in different cultures, some families are multi-generational, where grandparents, parents, and children all live together. In Western culture, it typically is just the parents and children. But I did mention that there have been changing forms of families. So particular changes include the rise of de facto relationships. Not everyone in a intimate partner relationship is necessarily married, but even then, de facto couples still model their lives in a way that resembles a nuclear family. Some couples have children, and that substantive structure really hasn't changed. Then there's same-sex relationships, and a lot of people nowadays are single. So the idea of family has shifted in form, but I think people still identify that in substance, the nuclear family is still there, but it is embodied in different forms nowadays.
And do you think that the family and the whole idea of family still holds the same importance as it has done in previous years, say 5-10 years ago?
I think the family as an institution is still very important. It is the bedrock of society in terms of how people form their lives from a sociological perspective. Decision-making is localized to the family, and it's still seen as a system of kinship and support. So if an individual falls on hard times, they can still, hopefully in many cases, resort to their family for support. And as a society, particularly in the West, there has been an emphasis on the family. There's a principle known as subsidiarity, and it refers to the idea that decision-making should be localized. So there's the government, and they make decisions that affect the whole community. But for ordinary matters, as a society, and this is reflected in family law, decision-making should be made by individuals in the family context. So, for instance, in parenting matters, it's compulsory that the parents go through alternative dispute resolution, such as mediation, because the view is that it's their lives. They need to make decisions that promote the best interests of their children. So, as a society, there is still that promotion of the family as the primary decision maker in regards to major life decisions. And we have a Family Law Act in Australia, and in other countries, they also have family law legislation. So while there are different forms of family in the present context, the family as an institution is still very important in society.
And now, talking a little bit more about marriage and the whole idea of marriage, how would you define what the institute of a marriage is?
Okay, that's an excellent question. And in the Australian context, that has been up for debate, particularly in 2017 when there was a postal survey on changing the definition of marriage. I think to answer that question, it's worth starting with the legal definition of marriage and exploring how we got to this particular understanding of marriage. So in the Australian Marriage Act, a marriage is defined as the union of two people to the exclusion of all others voluntarily entered into for life. So there are some elements that are worth breaking down here. So marriage is viewed as a monogamous union. In past, it was viewed as a union between a man and a woman, but as a result of the changes to the Marriage Act in 2017, marriage nowadays can encompass those in a same-sex relationship as well as those in an opposite-sex relationship. It is monogamous because there's an emphasis that marriage is to the exclusion of all others. It's voluntary, and that expression does have legal meaning. In other societies, there could be forced marriages, but in Australia, to enter into a marriage, it has to be done with the consent of parties. And the expectation is that marriage is for life. And that is quite a noble aspiration, but in practice, in Australia, about 50,000 or so couples get divorced each year. So as a matter of public policy, the aspiration is that marriage is for life. But of course, divorce law also exists. It's not necessarily for life for everyone else, but it is still the ideal.
So when it comes to the idea that marriage is for life, for example, as one of the key components for a long-lasting marriage, do you believe that that is essential for a successful... Hang on, I'm getting my question mixed up. Sorry, that is on my end. So what are some of the key and components and key expectations that are essential for a successful and fulfilling marriage according to some of the legal terms that you mentioned?
Oh, okay. Well, that's quite a profound question.
Yeah.
I'm not necessarily an expert on what makes a happy and fulfilling marriage, but I have read a lot of family law cases involving divorce and the other end of the spectrum. I can tell you why marriages have broken down. So marriages have broken down as a result of extramarital affairs. People often get divorced in their 40s. So if you look at the median age of divorce, it's around the 40-year mark of their lives. The reason being is, I guess a lot of people have midlife crises. They once fell into love, but over time they couldn't sustain the relationship together as a couple. People's personalities and priorities change over time. So there are all sorts of reasons why marriages break down. So financial stress is another big issue as well. Unfortunately, in society, family violence is a big problem that causes the breakdown of marriage. So that explains the unhappy side of why marriages break down. To promote a happy marriage, well, I think couples have to try to remain committed with each other. In life, people go through all sorts of challenges, and people either grow together as a result of overcoming obstacles, or in other situations, these challenges are insurmountable and it puts too much pressure on the relationship, causing breakdown. That's just a snapshot of some happy marriages and what unhappy marriages may look like.
Mm-hmm. And how has the concept of marriage evolved in recent years?
Yeah, so that's an interesting question as well. So I just gave a legal definition, but it's worth exploring whether people still get married and how they get married. De facto relationships are more common. Marriage isn't seen as the default to display to the community that a couple are in a committed relationship. So that's changed. There are different forms of intimate partner relationships, so one being marriage, other being de facto relationships. And in terms of how people get married, that has significantly changed. So 100 years ago, most people would get married in a church or in a religious context. But nowadays, most people get married before a civil celebrant. A non-religious civil ceremony. So nowadays in Australia, the vast majority of couples have a civil marriage before a civil celebrant. So that has changed significantly. And as mentioned, the definition of marriage has recently evolved to encompass those in same-sex relationships. So marriage historically was viewed for the procreation of children, to ensure that there was a stable environment for the upbringing of children. also to ensure that there was an institution that supported those in committed relationships. There was a visible public sign that a couple were together. And also bear in mind that historically Western societies were very Christian societies. The idea was being a committed relationship was a way to avoid fornication or other sexual sins. So it had those purposes. But nowadays, people get married or are in committed de facto relationships because of choice. People want to pursue happiness. I would describe the phenomenon as eudaimonistic liberalism. So in other words, people trying to pursue happiness and having the free choice of finding meaning in life through a partner, even in the context of marriage or a de facto relationship.
Mm-hmm. And throughout that evolution, the evolution of how marriage sort of comes about, and what are some of the new opportunities that this new idea of marriage and this whole new evolution of marriage, how does that sort of take place within any new marriages that are entering or starting now? Is there any benefit to how it can be seen now compared to how it can be seen in previous years?
I think the law and society is more tolerant of diverse ranges of relationships. And the law still tries to promote these stable relationships as being the ideal. In law, there's often a distinction between formalities and substance. So, as I alluded earlier, there are different forms of relationships that people can now undertake, whether that be a marriage or a de facto relationship. In other jurisdictions, there are civil unions or civil partnerships or registered relationships. But in substance, despite different forms of legally recognized relationships, in substance, these relationships are effectively the same in the sense that the law is trying to promote commitment, stability. Marriage is seen as a source of kinship support, that you rely on your spousal partner throughout life, particularly during challenging circumstances. And being in a legally recognized relationship has legal consequences. For instance, when the person passes away, typically their spouse or partner will inherit the family property. So it has to be, the marriages and marriage-like relationships need to be seen in that context as a system of social support. Obviously, there is the romantic aspect of being married and declaring your public commitment to your friends and family. But there are also public policy reasons why marriage is still important, because it does provide, that system of kinship support. Your partner or spouse can provide you love. The government can't love you in the same way that being in a relationship can. So that's the reason why marriages are still important.
Mm-hmm. I think especially when you mention the legal ramifications when it comes to even, I guess, children, when sort of children come into the picture, there's that chance that that marriage is sort of there legally to protect the kids as well, knowing that the children will go to the other parent, will go to the parent that's there in order that they trust as well. So there is sort of that legal aspect. I'm assuming if that's the case, is how it will go with how children are involved as well.
Yeah, so in regards to children, they have their status recognised in the context of family. So historically, children born out of wedlock were viewed as illegitimate children, and they wouldn't have the right of inheriting property from their biological parents. Obviously, nowadays, those illegitimacy laws have been abolished, but it is important how the law does recognise the status of the child in the family, not only for the purposes of inheriting the estate when a parent passes away, but also in terms of recognising who has the responsibility for the child's upbringing. The law formally recognises that parents have the responsibility for the upbringing of the children. Parents are expected to make decisions that promote the child's best interests. So having family law that recognises parental responsibility as well as children's rights is very important. Children also have views, and they have the right to express their views. And this is often a conundrum within family law cases, because the parents want one thing, but the child may want something else. The child may not necessarily want to live with dad, but the court needs to make a decision that will be in the child's best interests, not simply what the child wants.
Now, trust is fundamental in any relationship. How can couples build and maintain trust in the context of prenuptial agreements?
Yeah, that's a fantastic question, because bringing up a prenuptial agreement on a date isn't really the most romantic thing to do. And when people date, they don't often exchange their financial records. And awkward questions do have to be raised, because even when couples get engaged, it doesn't mean that each party has a true understanding of the financial status of their partner. So it can be tricky to ask point blank, how much money do you have? So there is a degree of sensitivity that needs to be borne in mind when discussing prenuptial agreements. I think it's an important question. I think you need to be honest. And nowadays, there are a lot of marriage preparation courses, and in these courses, the couple are asked about financial questions. I think it's important to have that full disclosure, that you're not hiding any assets, that it's clear how much money each party has. It can get very emotional, especially in talking about your sense of worth being construed in a financial sense. One tip would be to not always talk about financial matters. Talk about financial matters when you're in a position to do so, because if you just had an argument, it's probably the best idea to talk about finances. Yeah. Some people would suggest that you only talk about prenuptial agreements when you see your lawyer and you have that formal legal discussion, and not to always bring it up at the dinner table, because there could be emotional pressure. It's also, as I've mentioned, a little bit uncomfortable to constantly be discussing. So to have that separation, that you know that you'll talk about prenuptial agreements in that legal context, or when you're going for formal negotiations. That way there's separation. It's like working in a family business. It would be a bit unhealthy if the family members always talked about work. So it's having that distinction between work and life, as well as talking about financial affairs and getting on with the rest of your life affairs.
And how can that conversation really be sort of promoting a greater sense of trust between the partners?
I think a full and frank discussion promotes transparency. That way there are no surprises during the marriage or after separation. It can promote a sense of trust that you have faith and confidence in your spouse or partner to discuss these sensitive financial matters, and having that full transparency, I think, does promote the relationship rather than hiding things. I think disputes arise when there is misunderstanding or when people have been opaque and unclear. That's when arguments may arise. So being full and frank about one's position.
And I think especially a lot of people sort of take that whole prenup agreement, that whole prenup list as something that sort of remarks the not being trust in the fact that this person is wanting a long marriage or this person is wanting a longevity in the marriage. Why is that such a viewpoint that a lot of people have?
I think it's an understandable reaction, given the fact that if you're asked to write a prenuptial agreement, the assumption may be you don't completely trust in our relationship, you don't think that things will work out. Why are you preparing for the demise of our relationship when the relationship has just begun? So these are natural concerns. I think particularly for those who have been married, going for their first marriage. It's less controversial when you're considering those who have been divorced and are up to their second or later marriage. There is more life experience and understanding that a prenuptial agreement is a sensible topic to discuss. But for those couples who are getting married for the first time, who haven't had the experience of marital life, prenuptial agreements can be a sensitive topic. But as I mentioned, look, it's not for everyone. Not everyone needs a prenuptial agreement, but if there are significant financial assets, if there is a need to protect intergenerational family wealth, then it would be reasonable to discuss finances, given the huge consequences if divorce were to occur. I mean, for the most part, many people who are getting married for the first time, they're likely to be young. They probably don't have significant assets. There's probably no real need to have a prenuptial agreement in that context. So from a practical perspective, it's worth considering what sort of people enter into prenuptial agreements. And one class of couples that enter into prenuptial agreements typically involve one wealthier party marrying someone who is less financially well off. And quite naturally, the wealthier party wants to protect their assets in the event that divorce occurs. So there is a gender dynamic as well. A lot of people who enter into prenuptial agreements do so to protect their wealth for their children or for themselves. It's not uncommon. In fact, it is quite common for a wealthier man to ask their younger wife to enter into a prenuptial agreement. There is imbalance, and there's always going to be a degree of imbalance when entering into these sorts of agreements. But the law recognises that people have the freedom of contract, and it's up to each party to decide how they wish to divide the property should separation occur.
Mm-hmm. So there's a lot of stereotypes attached to the who's more likely to ask for a prenuptial agreement.
Yeah, I think the stereotypes are rooted in facts. They may be a bit exaggerated, but as I mentioned, a classic example would be a wealthier man who may be onto his second or later marriage, marrying a younger woman. So that's one type of situation where a party would wish to have a prenuptial agreement. Another scenario, which is a little less known, is in the context of dynastic wealth. So this involves a person who has wealthy parents. Their parents may have a big business, and the expectation is that the child will eventually inherit a lot of wealth. And in that situation, the parents may put pressure on their child to sign a prenuptial agreement for getting married in order to protect the generational wealth within the family context. So that's the second class of couples who have prenuptial agreements. The third class are those who are on to their second or later marriage. And in these sorts of situations, there is more likely going to be power balance. So if you have a couple, each party has been divorced and they're on to their second marriage, they each have life experience. If they're roughly the same age, they would have similar amounts of wealth, and they would be in a position to more fairly bargain. But the problem with prenuptial agreements is that you could have a situation where the younger, more vulnerable party who has less financial resources feels pressured to signing these prenuptial agreements. And in that context, that vulnerable party may not be making the best decision for their financial future. So in those situations, there is clearly a power imbalance. The more vulnerable party may be more willing to accept unfair terms just to have that relationship, because the wealthier party can just simply say, if you don't sign the prenuptial agreement, the marriage is not going ahead. In that situation, it's effectively an ultimatum. Now, even though in the law it is a requirement that each party seeks independent legal advice, it doesn't necessarily ameliorate the unfair bargaining positions because, as I mentioned, if the wealthier party says you must sign the prenuptial agreement before we get married, if you're in a financially vulnerable position, if you have migrated to Australia and are on a temporary visa, then you don't really have a strong bargaining position to begin with, and you may just simply accept the terms set out in the prenuptial agreement. And there was a High Court case recently on this issue called Fawn and Kennedy, and the facts involved a wealthier Australian man in his 60s falling in love online to a younger woman in her 30s from Eastern Europe. And a few days before they got married, the wife was pressured into signing a binding financial agreement or a prenuptial agreement that was disadvantageous towards her. So effectively, the terms of the agreement would have left the vast majority of the property to the husband, and would have left the wife with only a little bit of money. So this is the problem with prenuptial agreements, because the idea of prenuptial agreements is attempting to balance competing public policy aims. On the one hand, the aim of prenuptial agreements is to promote personal choice and autonomy, to avoid going to court, to make decisions that the parties agree to. So freedom of contract. On the other hand, as a society, we don't want people to be left penniless. We don't want people to be left in poverty after signing a disadvantageous prenuptial agreement. In Australia, it is possible to set aside a prenuptial agreement if it has been formed as a result of unconscionable conduct or undue influence. but there is no provision in the Family Law Act that states that prenuptial agreements must promote substantial fairness or to avoid serious injustice. So New Zealand has a provision that states that a prenuptial agreement can be overturned if it would promote serious injustice. That doesn't exist in Australia. So you could have a situation where parties have entered into a prenuptial agreement on unfair terms. Now, one might argue that's their choice. People are free to make bad decisions in life. On the other hand, as I've mentioned, some people are pressured into entering into prenuptial agreements because they don't have significant bargaining power. So this is the balance that needs to be promoted. On the one hand, promoting freedom of choice, but on the other hand, ensuring that there isn't exploitation of vulnerable parties that may lead them into a situation where they're in financial distress or poverty after separation.
Wow, it's amazing that we don't have that policy to sort of find the balance between. So when it comes to one party wanting the prenuptial agreement and one party not wanting that prenuptial, that list of terms, which way does it favor? Does it favor towards getting the prenuptial agreement, or does it favor towards the other party?
Okay, so for a prenuptial agreement to be legally binding, both parties must sign it, and they must each have separate legal advice. You can't force someone to enter into a prenuptial agreement, but the court can set aside a prenuptial agreement if they find that there are vitiating factors, or in other words, factors that spoil the validity of the prenuptial agreement. So as I mentioned in regards to the High Court of Australia case, the court eventually did set aside the prenuptial agreement because they found that the husband had exploited his position by preying upon the special disadvantages that his wife was under. She was from overseas. She only had a few days to contemplate the prenuptial agreement. Otherwise, the marriage would have been cancelled, and that would cause significant embarrassment to herself and her family, given the fact that friends and family had flown in just for the wedding. So in that situation, there's no free choice, and it will be unconscionable to exploit someone's special disadvantage in that situation. You have to think about the alternative. So if a prenuptial agreement is not valid, then you have to go through the family court system and go through the Family Law Act. So the Family Law Act looks at each party's financial and non-financial contributions to the relationship and their future needs. So the court deals with these sort of family property cases based on these contribution and future needs factors. And if you enter into a prenuptial agreement, you are contracting out of these legal safeguards. That's the risk. So if you're a non-moneyed spouse in a more precarious financial situation, you may wish to be under the standard sections of the Family Law Act that deal with the division of family property, rather than being in a prenuptial agreement that contains unfair terms, because the court will ensure that party is not left in a state of destitution, that their basic needs will be met. So there's a remedial function that the Family Law Act provides. But if you have a prenuptial agreement, you are contracting out of that and potentially agreeing to unfair terms. That said, just to be fair, many agreements are contracted on an equal basis, and there are fair terms. And the advantage of a prenuptial agreement is that you don't have to go through the expense and the time of court litigation. The idea is that the parties have consciously agreed on how the property should be divided, and parties should just simply follow what they have set out in the prenuptial agreement, because it take years and years for a matter to be heard by the judge, and it is a very expensive endeavour to go through the family justice system.
Mm-hmm. And just to be clear, I know that you've listed some of the common sort of prenuptial terms that would come about. What are some terms that are a bit more on the side where legally you won't agree to? So some unagreeable terms that are listed that you can sort of list out for us.
Yeah, so unfair terms would include one party getting nearly everything and the other party getting a small amount. So, for instance, to use the High Court case that I mentioned, the case is called Fawn and Kennedy. Mm-hmm. The wife was provided, I believe, $50,000 upon separation. And bear in mind that the husband's estate was valued between $18 to $24 million. So
wow.
You can clearly see that is an unfair term. In fact, when the wife saw the lawyer said, "This is the worst prenuptial agreement that I've ever seen. Please don't sign it." But obviously in the circumstances that she found herself in, she had no choice but to sign it, because if you didn't sign it, the marriage would have been called off. And she signed the agreement twice. There's something called a post-nuptial agreement. So she signed the prenuptial agreement with those unfair terms. Then after they got married, she signed a post-nuptial agreement with effectively the same terms. So you would think that because she signed the agreement twice, it was legally solid and would be able to withstand litigation. However, the court found that the wife here didn't really have free choice to make that decision. It was unconscionable for that decision to be made. And nowadays, lawyers are a little bit reluctant to encouraging parties to enter into these prenuptial agreements, particularly if the contract, the prenuptial agreement, is formed a few days or a few weeks before the wedding, because in that situation, you can see that a party may not necessarily have a choice, because if they don't go ahead, the wedding will be cancelled. And that obviously means that a vulnerable party is left in a very difficult situation. So those are examples of what would look like unfair terms, where one party gets nearly everything and the other party gets peanuts, just a few things.
Yep. Okay. And now we're going to move on to some of the practices that can sort of take place in sort of ways to discuss the prenuptial agreement and to bring up the topic. Now, what are some steps that you would recommend to couples when discussing and negotiating those prenuptial agreements to ensure that they have a healthy and sort of an open conversation?
When people get married, it's a big life decision. And I would encourage couples to have go through a marriage preparation course. There are trade experts that can help you deal with some of the contentious questions when you get married. So one potential area of conflict is financial disputes. So I think going through marriage preparation courses provides a formal setting where these issues can be aired in a more objective way, in a less emotional setting. Obviously, you could just simply have the frank discussion at home or with your partner and discuss these matters. However, it may lead to conflict if there are different values about how money should be spent and the value of money. So having a third party mediate or facilitate discussions can help, and that's why a marriage preparation course can be helpful. Otherwise, if you are planning to enter into a prenuptial agreement, you can speak to your lawyer and have your discussions in that legal context. So, as I mentioned, you want a division between your legal discussions and your day-to-day life. You don't want to constantly bring up the issue of prenuptial agreements and say, how come you didn't add this particular term to the agreement, and constantly badger your partner about it. That's not a good idea. So having that formal setting may help promote a conducive outcome.
Okay. And looking into some of the challenges that can sort of come about, especially when going through the marriage preparation course, what are some of the challenges that could occur when going through those courses, or when even finding those courses?
I don't think it's too hard to find courses. There are a lot of providers out there.
Okay.
There are non-government providers, as well as religious providers like church. So finding them shouldn't be too hard if you do a basic Google search. But in terms of going through that process, it's an eye-opening experience, because when a couple is engaged, they're in their honeymoon phase, think their partner or spouse is perfect, and it may be worth reflecting on some of the challenges that may be encountered once they get married. So having a time to reflect upon some of those challenges, including finances, is important. That way you are prepared, that you're ready for potential areas of dispute, because conflict arises typically as a result of miscommunication. Agreements can occur because one party doesn't feel the other party has been fully transparent. They may feel that the other party has been evasive or has hidden things from them. So transparency is key for any healthy relationship.
Okay. No, I love I think that keyword today is going to be transparency and being open, because I think that's such an important part of having that conversation, even before the prenuptial agreement sort of takes place. Now we're going to go into our open mic section, and now this gives you a chance to talk about something that we have missed today, or something that is of interest to you as well. So in the last couple of minutes, I'd love to give you the floor and just share any thoughts that you have for today.
Okay. Well, I think it's worth comparing how other countries deal with prenuptial agreements, because there is a spectrum of legal responses. So in many states in America, if you sign a prenuptial agreement, the view is that it is legally binding. They have a strong view about the sanctity of contract. So if you follow celebrity culture, or watch American TV shows, or listen to American music, there's a lot of references to prenuptial agreements, and they are seen as legally enforceable. I mean, they can be set aside, but you would have to demonstrate that there's been duress, basically a party had been forced to enter into it. And there is, as I said, sanctity of contract. So if you agree to unfair terms, well, that's just too bad. You have to live with the consequences of your decision. New Zealand takes a different approach. So in New Zealand, yes, prenuptial agreements can be legally binding, but they can be set aside for more reasons than in Australia. So as I mentioned, if enforcement of the prenuptial agreement causes serious injustice, then the court can overturn the prenuptial agreement, and they will come under general family law provisions in New Zealand. In Australia, we're somewhere in between America and New Zealand. So there is promotion of freedom of contract. You're free to enter into whatever terms that you wish. But it is possible to set prenuptial agreements aside for reasons such as unconscionable dealing or undue influence. And these factors are interpreted more expansively compared to the situation in America. You wouldn't be able to make that argument in the United States in many jurisdictions. But we don't have a procedural fairness or a serious injustice provision in our laws. So as I said, it's somewhere in between. The UK approach is also a bit similar to Australia as well. So in terms of how to improve the legal system, I personally like the New Zealand approach. I think parties should have the right to decide how they wish to divide their property upon separation. It is their lives. They need to make decisions that will be in their own interests. And we don't want parties to constantly litigate court because it's costly, time-consuming, and it's not desirable for promoting good outcomes. But at the same time, we don't want exploitation. We don't want vulnerable parties to be left in a state of poverty. We need to ensure that vulnerable parties are protected with legal safeguards, such as a provision that would set aside a prenuptial agreement if it promotes serious injustice. And it's not only an issue that affects the couple, it also affects society more broadly, because if a person separates and divorces, they are left in a financially precarious situation. And if a person ends up on social welfare, there is a cost associated to the taxpayer. It causes societal problems. So we do have to think about the wider context. There is obviously a dispute among private individuals, but there are also public policy and social outcomes that we need to think about. We want a society where there are stable relationships. We want a resilient society, and we want those who do decide to separate and divorce to be left in a secure financial position.
No, I think especially when it comes to the case that you were talking about earlier, the Thorne versus Kennedy, if that was in a New Zealand circumstance, then a completely different outcome without the safeguard, I guess.
Well, with Thorne and Kennedy, the prenuptial agreement was set aside, but if that case was heard in America, maybe not. It might have been too bad for the wife because, well, she went to a lawyer twice and still signed the agreement nonetheless. With the New Zealand approach, if a set of facts that was similar to Thorne and Kennedy were heard in New Zealand, the prenuptial agreement could just simply be set aside for serious injustice. There would be no need to argue undue influence or unconscionability because those factors attack the validity of the contract itself, whereas a serious injustice provision is a statutory safeguard to ensure that enforcement of prenuptial agreements don't lead to adverse outcomes for the vulnerable party. Yeah, you can see it's tricky because you want to respect people's free choices, even choice to make bad decisions. But at the same time, we obviously need to ensure safeguards for vulnerable parties. So, for the courts to intervene, it kind of overturns the idea of a prenuptial agreement, an agreement that the couples have made. But at the same time, we do need to promote good public policy as well.
Yes, no, I definitely agree with that, especially if later on down the line, children are involved and situations changed again. There is that availability for the understanding of change in circumstances, which also fits really well. And that is such a great way for us to sort of sum up the show and talk about what we were, and sort of end on what we were talking about today, because I think there's a lot of lessons learned in a lot of legal practices that we spoke about today, and especially in the cases of Thorne and Kennedy. I think that is a very interesting case that we don't really hear about those sort of cases that really play really well into how society works today in regards to relationships. So thank you, Henry, so much for joining me on the show today.
Thank you, Dina, for the opportunity. I really enjoyed talking about prenups with you.
Yes, no, I definitely can see the enthusiasm. I think I love talking about this as well because we don't get to speak about it quite often. If there's a way that audiences would like to get into contact with you to ask questions that I have missed, or to just sort of discuss some of these topics that we spoke about today even further, is there any contact information that I am able to give out to the audience?
Sure. The audience can get in touch with me by emailing me. So I have a Macquarie University online profile. So if you just simply type my name into Google, you should be able to find my Macquarie University profile, and it will have my email address.
Okay, perfect. Well, I will have that down in the link as a link down below for easy access for all our audience. Thank you so much again, Henry, for joining me. If you guys have any questions, feel free to either put it in the comments down below or even send it over to Henry. I'm sure that will be an amazing sort of conversation to have. So thank you guys so much for listening. I will see you all in the next episode. You've been listening to All Together, the Family Science Insights podcast, produced by the Family Science Labs, a division of LMSL, the Life Management Science Labs. More episodes are available from 10 life management perspectives and can be found by searching LMSL on Apple Podcasts, Google Podcasts, Spotify, and other podcasting apps available on your devices. If you enjoyed this episode, please consider rating our show, sharing it, and subscribing to our channel, as it helps other people find it so that we can grow and bring you more quality resources. More of our work can be found on our website at fa.lmsl.net, where you can join our movement. I'm Dina Sargeant. Thanks for tuning in.